Hey guys, welcome to this video. My name is John Watts. I'm a consumer protection lawyer, and I recently had a hearing on a motion for summary judgment and wanted to share with you a little bit about motions for summary judgment. Now, I'll be telling you from the standpoint of the Alabama version of Rule 56, which is typically the rule number under your Rules of Civil Procedure for summary judgment. Federal Rule 56 is very similar. And now if you're in a different state, it may or may not be similar. So you certainly have to look at it. And that's the first point is you've got to look at the rule to understand exactly your obligations and your options on what you can do. But let's take a step back. What is a summary judgment motion? Well, a motion is where you ask the judge to do something. And so a summary judgment is where you're asking the judge just summarily enter judgment. There's no reason to have a jury trial, no reason to even have a bench trial where there's no jury. Just go ahead and give us judgment now. Now, that can be for the whole case, to wipe out the whole case, or it could be maybe just on one issue. So sometimes the plaintiff, the one that's brought the suit, is asking for summary judgment just on liability, okay, just on whether the defendant is at fault or not at fault. And then the plaintiff says, but we'll leave damages open for the court or for the jury. Now, again, it can be the defendant asking for just a partial summary judgment, maybe on willfulness or wantonness, but they say, we understand negligence goes to the jury. And so that's the basic idea is let's not have a trial on things that no reasonable juror could disagree with. Now, if you're facing a summary judgment motion, again, you have to study the rules. And obviously, if you have a lawyer, your lawyer will handle this. But if you're doing it on your own, the judge is going to expect you to know, what does the rule, typically 56, say about summary judgment? So there's a couple ideas. One is that the person moving for summary judgment is entitled to judgment as a matter of law. In other words, they're correct on the law. So that's an angle to fight this is say, no, they've got the law wrong. Okay? They say the law is this, actually the law is something else. But the more common issue is what's called a disputed factual issue, sometimes called a material fact. In other words, an important fact, a fact that would make a difference. And there's a dispute that either the jury or the judge, if there is no jury, will have to decide. So let me give you a simple example, then we'll look at a little bit more complicated example. Simple example would be a car wreck. So the defendant files summary judgment and says in an affidavit, which is typically how you put forth the evidence, or in a deposition, says, look, I had the green light, the plaintiff had the red light. And so yes, we crashed in the middle of the intersection, but I had the right of way. Well, now that shifts the burden to the plaintiff, the one who was injured, to say, well, how are you going to dispute that? Well, if the plaintiff gives an affidavit or a deposition that says, no, I had the green light, he had the red light. Well, who's right? Well, the judge is not supposed to decide that, at least not in normal circumstances, at summary judgment. Here's some evidence the defendant had the green light. Here's evidence the plaintiff had the green light. So that's something that you say, well, look, that's a disputed issue of fact. Pretty important. Who had the green light? Let's let the jury decide that. Well, let's think about in a different context. Maybe you're suing a credit bureau under the Fair Credit Reporting Act. And you say, hey guys, I sent you a dispute and it was a valid dispute. I identified errors and you refused to fix it. And the credit bureau says, we never got it. And they offer an affidavit or deposition testimony. We never received it. So if we didn't receive it, we're not obligated to do an investigation. Well, if they move for summary judgment and those are the only facts in front of the judge, then the judge is going to rule in favor of the credit bureau. But what if you put forth an affidavit? You say, no, that's wrong. I did send it. Matter of fact, I sent it by certified mail. Here's the signature. Or I submitted it online, go to Equifax.com or Experian.com or wherever, and you submit it online, and here's exactly when I submitted it. Matter of fact, here's a video. I'll attach that to my response that shows me logging in, selecting the account, selecting the reason, uploading documents, maybe even a letter that explains my dispute. And so there is no, It's not undisputed that I didn't make a dispute. Actually, if anything, it's undisputed I did make a dispute. Okay? So you should at least not grant summary judgment in their favor. Now, sometimes we have cross motions for summary judgment. So the credit bureau might say, you didn't submit a dispute, we want summary judgment. You might move for summary judgment and say, I did submit a dispute. Now, the judge might say, well, I'm going to let the jury decide, or the judge might say, rule in favor of this side or that side. So the point is that you really have to study these motions for summary judgment and understand how to respond. What's the format of the response? In other words, I'll see people, even lawyers do this. They'll just like print out stuff off the internet and attach that to their brief. They're like, there's my evidence. Like, well, that's not in the proper form. It needs to be interrogatory response or deposition or affidavit, whatever your rule says about what a proper response is. Then there's the timing of this. Now, I think when this video is going up, it should be the day after I did a video on my car talking about, what if you miss the timing? And I've had that happen where people hire us right before the summary judgment. And so technically we're too late, but we go ahead and file a response anyway. Obviously, you don't want to be in that position. You want to file your response within the time limits, file it the correct way with court, serve it the correct way on the other side, put it in the right format so that the judge has no excuse to reject it. Okay? And so, again, I can't go into all the details of summary judgment, but read your rule, typically Rule 56, and make sure you have a good understanding of how do I respond to this, when do I respond, where do I respond, what's the format I respond, and then you're looking to show that they're wrong on the law and or that they're wrong on the facts, that there are disputed issues of material fact. So we need a jury to decide. Just think about that car wreck example. Two cars hitting and they both say they had the green light. Well, who's right? The judge can't decide that. We need a jury to decide that. Okay, I appreciate you guys watching this. Hope that's helpful to you, and I will see you tomorrow. Okay, have a good one. Bye-bye.